You are now listening to the Fighting Back podcast, and here's your host, Jessica Travis.
Welcome to the Fighting Back podcast. I'm your host, Jessica Travis, and today it's Appeals 101, Checks, Balances, and the Court System Explained. My guest today is Michael Ufferman, a highly respected and board-certified criminal appellate attorney and the founder of Michael Ufferman Law Firm in Tallahassee. Michael has spent more than 20 years focusing exclusively on criminal appeals and post-conviction work in both state and federal courts, and has received numerous awards and honors for his dedication to the practice. Thank you so much for joining me today, Michael.
Thank you, Jessica, for having me. It's a pleasure to be with you.
Now, given your extensive background in appellate law, I'm excited to talk to you about how the legal system works. But I kind of want to start broad at first. So let's talk about the foundations. Can you give us an overview of the three branches of government and how checks and balances work in the United States?
Of course. So when our founders created our great democracy and they established our Constitution, they established three branches of government, the executive, the legislative, and the judicial. And they each serve very different roles. So most people know this. Some of us that are my age, maybe you remember that cartoon that used to be on Saturday mornings, How a Bill Becomes a Law.
Yeah.
The legislative branch is the branch that makes the law. So Congress, if we're on the federal level, are the ones that get together and they establish what a new statute or what a new law might be in our country. After a law is established, then the executive branch is the branch that enforces the law. So most everyone knows that the executive branch involves the president of the United States being at the top of the executive branch. But we have several entities that are under the president that are also part of the executive branch. So in the federal system, we have the Department of Justice and U.S. Attorney's offices, and those are the entities that enforce the law and charge people with crimes should they break the law. And then finally, we have the judicial branch. And the judicial branch's sole role is to interpret the law. So if Congress passes a statute and someone might question whether that statute violates the Constitution, perhaps it's a statute about how loud a stereo could be played late at night. And someone might say, well, I have a First Amendment right to freedom of speech, and that First Amendment right of speech covers or allows me to play my stereo as loud as I want any time of day. That law could be challenged, and the court would consider whether or not that law that would maybe put a ban on loud playing of stereos late at night violates the First Amendment or not. So that's the role of the courts. There is some controversy. Sometimes some people say that the courts try to also rewrite the law when they're considering these cases, and they have the ability to strike down a law that they might find is unconstitutional, but do they have the ability to somehow rewrite the law in its place? And generally speaking, the answer to that is no. Courts should interpret what the law is. If it's determined that a law is unconstitutional, then Congress would have another chance to pass a different law, and that could be challenged again. But it's not the role of the courts to write the law. It's only the role of the courts to interpret the law.
And when we're talking about the court system, the judiciary branch itself is also tiered, right?
Yes, it is. So if I was focusing on Florida right now, and I'm a criminal appellate lawyer, so I only represent people after they've been convicted. I'm not a trial guru like the lawyers at the Fighter Law Firm who are good on their feet and like to be in the courtroom and arguing to juries. As an appellate attorney, I only represent people after they get convicted. So the tiers of courts within the state of Florida, we have three tiers of courts. Maybe even say four, but we have trial courts, and within trial courts we have both county courts, which from a criminal standpoint hear misdemeanor cases, and then we have circuit courts that hear felony cases.
And we are there all the time.
Yes, and so anyone who gets convicted, and this has changed over the last couple of years. It used to be that when someone was convicted of a misdemeanor, they would appeal their case actually to the circuit court. But the law changed. The legislature in Florida changed the law. And they said now anyone convicted of a crime, whether it's a misdemeanor or a felony, they appeal to one of what we call our 6 district courts of appeal, DCAs for short, District Court of Appeal. And we have one of those district courts of appeal for every region of the state of Florida. So just by example, the First District Court of Appeal runs from Pensacola, the furthest west point of our state, over through Tallahassee to just west of Jacksonville and down to Gainesville. So anyone convicted of a crime who wants to appeal that conviction would appeal to the first DCA.
And we're in Orlando. So
yes, Tampa is the second. Just to quickly go around the state, the Miami is the third, Fort Lauderdale and West Palm is the fourth, and the fifth is now Jacksonville. And Orlando used to be in the fifth, but just a couple of years ago, we added a new District Court of Appeal, the Sixth District Court of Appeal, which kind of is a swath down the side of our state from Orlando all the way down to Naples.
So, because of your extensive experience with criminal appeals, can you briefly talk to us about what is the process of a criminal appeal? I mean, I think everybody watches TV and watches the legal shows that show the trial part of it, the courtroom, and then whether somebody is found guilty or not guilty. But what happens after that?
Yeah, I'm still waiting for the call from one of the big networks to ask if I want to star in a new upcoming TV series about criminal appeals. It hasn't happened, and I don't think it will happen because it's very different from what happens at the trial court level. Again, trial attorneys, when someone gets charged with a crime, they retain a trial attorney. There's a process up until the time, or up until that case may go to trial. Most cases never go to trial. They plea out, and in some cases do go to trial, and it may end in a criminal conviction. Again, people know about that. They watch Law and Order or some of these other shows. But from there, what happens with an appeal is very different. So the trial attorney, if the case does go to trial, takes the case to court. They select a jury. They present witnesses. They make arguments to the jury. All that happens in the courtroom. As an appellate attorney, I'm kind of considered the legal nerd of the criminal attorneys in the state of Florida.
Yes, you are.
Yeah, yes, I am. I rarely go to court. So when someone decides to appeal, they simply file a notice of appeal with the trial court, letting the trial court know that this case is going to be appealed to one of those 6 DCAs, depending on where the case comes out of. And then the process, unfortunately, it's a very deliberative process. Each criminal appeal in Florida takes on average about a year. It's not a short process. And the reason for that is the first thing that has to be done is every time someone was in court and discussing matters that were important, certainly from the trial, that trial has to be transcribed. So a court reporter has to make a transcript out of what happened during that trial. And that's because that's what the appellate judges are going to rely upon to determine what happened at trial. They're not going to listen to the recording of the trial. They're not going to watch a video. They're going to read the transcripts because we can read much faster than we can listen.
They're not going to have the trial attorneys tell them what happened?
Yeah, yes, right. So the first thing for an appeal is that the record is prepared, and then the way an appeal is heard by an appellate court is there are briefs that are submitted. And I don't know why they're called briefs because they're generally not very short at all.
They are not brief.
No, they're lengthy documents, usually 50, sometimes up to 70 pages long. So if I'm representing someone who was convicted, that person will be the appellant, and I have the ability to submit an initial brief which focuses on the facts from the trial and then also makes legal arguments as to things that went wrong during the trial. And then after I submit my brief, the Attorney General's office, not the state attorney's offices throughout the state, but the Attorney General's office will represent the state and file an answer brief. But as the appellant, I get the last word. I get to then file a reply brief. And at that point, after those 3 briefs are submitted, the case will be ready to be heard by the appellate court. So what are the types of issues that are raised on appeal? Generally speaking, there's a saying that the appellate court will not be a 7th juror. And in Florida, we generally have juries of 6 people. So the saying is that the appellate court is not going to be a 7th juror. They're not going to second guess the credibility determinations, the factual findings that were made by the jury or whoever the fact finder was. The focus of an appeal is almost always on legal issues. So for example, if prior to a criminal trial, if a defendant was interrogated by law enforcement and the defendant is claiming that interrogation violated his Fifth Amendment rights, that defendant might file a motion to suppress his statements to the police.
Right.
If the judge denies that motion to suppress and says, no, I don't think there's any constitutional issue here, then the jury would hear those statements. But then on appeal, if the defendant gets convicted, his issue on appeal may be, hey, the trial court made a legal error about whether or not those statements violated my Fifth Amendment rights. And that's the type of legal issue that the appellate court will consider. They generally won't consider any factual matters. They will only consider legal issues. And basically, in my briefs, every single claim begins with the words, the trial court erred by giving an improper jury instruction. The trial court erred by excluding evidence that the defendant wanted to present. The focus of a direct appeal is on errors that the trial court made, legal errors, during the trial. And then the last thing I'll say about that, I've mentioned that we have 6 district courts of appeal. They, on average, are made up of somewhere between 10 and 12 or 13 judges. But when a particular case goes in front of a district court of appeal, after the 3 briefs are submitted, the clerk's office, the computer at the clerk's office, will randomly spit out 3 names of judges who are on that court. And those will be the judges that are assigned to that particular appeal.
So we don't get to pick our judges for the appeal.
We do not get to pick our judges, and sometimes we don't find out who our judges are until very late in the process. And ultimately, to win the appeal, the appellant, and in my situation, it's generally my client who's a criminal defendant, must convince 2 of the 3 judges, or a majority of the panel, that there was in fact a legal error in the case.
And when you're talking about a legal error too, a lot of times the trial court will find one of the witnesses was lying or telling the truth, and my clients are convinced it's the other way around. So they'll often tell me, we have to appeal this because the trial court found that this person was telling the truth and they are clearly not. So let's go convince the appellate court that they're not telling the truth. Talk to me about that.
Great question.
I know the answer, but.
It's a great question. And one of the first conversations I have with my clients, that's what they will say as well. Michael, there's no evidence. And I was like, wait a minute, there was no evidence? The state didn't present any witnesses? Well, they presented a witness, but it was a co-defendant and he wasn't telling the truth. And then I have to say, now, appellate judges are going to look at legal issues. They're going to, because they interpret the law, they will look to see if the trial judge made the right legal conclusion. But the appellate judge will not make a credibility determination. And here's why. We already talked about the first thing that's done for an appeal is that transcripts are prepared. So these appellate judges, when they're reading what the witnesses say, they're reading it from what's called a cold record. They're reading it literally from pages of a transcript. However, when one is assessing credibility, when one is making a determination, whether it's a juror or a judge, about whether someone's telling the truth, there's a lot more than the actual words that they're saying that goes into that credibility determination. What did they appear like when they were on the witness stand? Were they sweating? Were they talking too slow or too fast that causes someone to believe that maybe they're not telling the truth? Were they not making eye contact? Those are decisions that jurors are allowed to take into consideration, or factors that are allowed to be taken into consideration when deciding whether or not they should believe a witness or not. That's not something the appellate judges are equipped to be able to do because they're not in the courtroom. They don't get to see that witness. And therefore, again, they're not going to second guess a credibility determination that was made by a jury on a factual matter. The only thing they're generally going to look for are legal errors made by the judge.
That makes sense. And so when you do finally get an opinion from the court, they've reviewed all of the briefs, they've made their decision, how does that opinion come?
So in Florida, in the last 10 years or so, maybe a little longer, we've switched to electronic filing, which has made my life as an appellate attorney so much easier.
Oh, yes.
When I first started practicing, when we would finish a brief, we would have to make several copies of that brief and literally have a runner or me, if it was a little after hours and my runner's gone home, and drive those briefs down to the appellate court and put them in the inbox for the appellate court by the due date. Yep. Now, pretty much everything in Florida, and this is true of every kind of case, whether it's civil, criminal, probate, you name it, everything's being filed electronically through what we call the e-portal in the state of Florida. So I don't have to make copies of briefs anymore. I can simply submit a PDF version of my brief through the portal, and that's how the appellate court will receive it. That's how the Attorney General's office will receive it as well. And when the court decides to issue its ultimate opinion, I will receive that opinion through an email from the portal, and it'll let me know whether or not I've won or lost. So if I'm the appellant representing a criminal defendant, I obviously want to win the case, have the conviction overturned. So what I'm looking for in the opinion, I just got one yesterday, I'm looking for the words reversed. I want the appellate court to reverse my client's conviction and sentence. If the word affirm is on the opinion, then that means that they are affirming my client's conviction and sentence and my client is lost. So there's a couple different ways those opinions can come out. If they're going to reverse, if the appellate court, the panel of 3 judges is going to reverse, they have to write a written opinion. They cannot reverse without giving an explanation. However, if they're going to affirm, that's not always true. Florida is one of few jurisdictions in the country that if an appellate court decides they want to affirm and they don't think it'll be of any benefit to write an opinion on that subject, then they can affirm by issuing what's called a PCA. And PCA stands for per curiam affirmed. It's literally a one-page order that simply has the word affirmed on it. Many times, in fact, 80% of the time that Florida courts affirm, they affirm with the PCA. The other 20% of the time when they affirm, they still affirm, but they write and explain why it is that they are affirming. So that can be frustrating to clients. It can be frustrating to me as the attorney that spent a lot of effort writing briefs and trying to convince the appellate court that I have 1, 2, or 3 good issues. At least one of these should require reversal. And then at the end of that year-long process, and both of those briefs that I've submitted, to have the appellate court come back and affirm and not give an explanation. But there's a reason for it. There's been a number of studies into the PCA process that we have in Florida. And the answer is we have a lot of cases. We're a very big state. If the appellate courts had to write on every single case that came in front of them, it would add a lot of worthless case law to our body of case law that already exists. So if the appellate court is considering a new issue, one that really hasn't been developed in Florida case law, that's generally an issue, whether they reverse or affirm, that they're going to write about, because the lawyers in the state, the general public needs to know what the appellate court's thinking is about that particular issue. Right. But if the issue that's been raised is an issue that's been raised literally hundreds of times in other cases, and the court writing about it would not add anything to the body of case law. It would simply be repeating what's already been said hundreds and hundreds of times. That's the reason why an appellate court will decide, hey, this doesn't need us to issue an opinion. We can PCA this, affirm this without an opinion, because to do otherwise wouldn't be adding to the body of case law in Florida.
So is that it? Once you get an opinion in the DCA court, is that where it stops, or is there any way to appeal that opinion to a higher court?
So it's interesting. When I started working out of law school, I got a job clerking for the Chief Justice of the Florida Supreme Court, and I was there for 5 years. So I'm very familiar with our Florida Supreme Court and how that process works. We hear people often say, I'm going to take my case all the way to the Florida Supreme Court. Or
all the time.
I'm going to the Supreme Court. I'm stopping at nothing to have my case reviewed by everyone. That may be true in other jurisdictions, and it actually could be true as far as the U.S. Supreme Court is concerned. But in Florida, our Florida Supreme Court has very limited jurisdiction. So I've already explained that there's anyone that's convicted, regardless of what part of the state you're in, you have the right to appeal to one of our intermediate appellate courts, one of the 6 DCAs, and they will review that case and ultimately issue an opinion. They're required to, one way or the other. So you have that first right of review. But the Florida Supreme Court only has to take certain types of cases. The main type of case from a criminal standpoint is a death penalty case. So if the jury imposes or recommends a death penalty and a judge imposes a death sentence, that case does not go to one of the intermediate DCAs. That type of case goes directly to the Florida Supreme Court. But having worked there for 5 years, I can tell you those cases are far more involved than your normal criminal appeal that goes to a DCA.
And the court has to hear that case and issue an opinion on it, correct?
They're required to. They are the appellate court that is deciding whether to affirm the conviction and affirm the death sentence. Obviously, a very serious matter. There's penalty phases in death penalty cases that can go on for several days, if not weeks. So there's a lot to review in each of those cases. The Florida Supreme Court takes that very seriously. So that takes up a lot of their time. They do have discretionary jurisdiction to hear other types of cases, but it is discretionary. They're not required to. The main 2 types of cases that a Florida Supreme Court will hear after the DCA has issued a written opinion, and I'm going to come back to that in a second, why the written opinion is important. If the DCA is affirmed or reversed and they've issued a written opinion explaining why, then there is the ability to seek review in the Florida Supreme Court. But the main type of case that the Florida Supreme Court will take is if the DCA says, hey, this is an important issue. It's one that hasn't yet been decided by any Florida court. This is our opinion as to how that issue should be decided. But we think this issue is important enough and could have an impact on other criminal defendants around the state that we think we should certify the question of great public importance and ask the Florida Supreme Court to accept the case. The Florida Supreme Court still isn't required to accept the case, but that's an invitation by the district court to take a second look at what the district court has concluded about that case. That's one area. The other area is what's called conflict jurisdiction. So if I get an opinion from the second DCA in Tampa that says it's not okay to drive a blue car on Sundays. And then another opinion has already come out of the fourth DCA in West Palm Beach that said it is okay to drive a blue car on Sundays. Obviously, those would be two different rulings, two different laws that would apply to different parts of the state. There'd be a conflict there between the second DCA's opinion and the fourth DCA's opinion.
Right.
The Florida Supreme Court has an interest in making sure that the law applies uniformly around the state, so we don't have different rules in Tampa as compared to West Palm Beach. So if there is a conflict, that's the way, probably the most common way that people who get a written opinion when they want to go to the Florida Supreme Court, they argue, hey, please take this case because the opinion we just got is in conflict with another district court of appeal, and you need to accept this case and resolve that conflict so the same rule of law applies throughout the entire state. But there's one caveat about that. So I mentioned that when Florida courts affirm, 80% of the time they affirm without a written opinion.
That's right.
If a DCA affirms with a PCA without a written opinion, there is no ability to seek further review in the Florida Supreme Court. And that's it. We're done. That's rule. There's no exception. They simply do not have jurisdiction to review an opinion that doesn't have an explanation, that simply says the word affirm. The only way the Florida Supreme Court can review a case is if the District Court of Appeal issued a written opinion explaining why they ruled the way that they did.
Now, I know we can't force courts to do anything, but is there any way to force or request that a DCA issue a written opinion if they've already given us a PCA?
It's a great question. So years ago, I chaired what's called the Florida Bar's Appellate Court Rules Committee. And we were asked to adopt an amendment. And this was pushed by Florida lawyers who were frustrated with getting PCAs, getting these opinions that don't have an explanation, that they wanted the opportunity to say, after that PCA or order that simply says affirmed came out, to be able to ask, hey, I think that there's an issue here that it would be worthy of the Florida Supreme Court considering. Will you please write an opinion? And the appellate rules were changed about 10 years ago to allow someone who receives the PCA to, within 15 days of that PCA, file a motion requesting a written opinion. And in that written opinion, you have to explain why, if the appellate court were to write an opinion, you think that there would be a basis to seek further review in the Florida Supreme Court. So it's nice that that rule was added. I'm a part of, and you probably are as well, Jessica, an in-of-court group here in Tallahassee where lawyers and judges on a monthly basis get together and have dinner and discuss issues. And it's really a good way to make sure that we have a friendly relationship with the other attorneys that we work with, and also have a friendly relationship with the judges. And at some of the in-of-court meetings, and they put on presentations at these in-of-courts, and this was one of the subject areas that came up a couple of years ago. And the question was, should an attorney, when they get a PCA, ask for a written opinion every time? And I think, without putting words in all from the judges who spoke at that presentation, I think the general consensus was, look, we knew when you submitted your briefs and when we were deciding how to resolve this case that, of course, you would have wanted a written opinion.
Of course.
And we made the decision to not give you one. It would probably be pretty rare that you could say something in your request for a written opinion that would get us to change our mind. But maybe. So the rule's out there. And if you think there's really a compelling reason, then by all means, the rule gives you that opportunity to make that request. But I do think it could be abused, and it shouldn't be asked for in every situation. It really should be a situation where perhaps the appellate court didn't think of something that, if they did write an opinion, it really would be a good reason for the Florida Supreme Court to review the case. So I would advise, number one, it's not something that's available in every case. Yes, technically it's available, but it's probably not a good idea to file it in every case. You may lose the confidence of the judges you appear in front of. And then B, when you do decide to request a written opinion, it should be for a compelling reason. But I will say that I've probably every other year I am able to, when I've decided to file a motion for a written opinion, I've been able to convince an appellate court to actually issue a written opinion. So it's happened to me probably 5 total times since that rule went into effect. So it
it
can
does
happen,
Okay.
but there should be a good reason for asking for it.
Of course. Well, thanks so much for breaking down these complex processes and issues that go along with the appeal process, and really helping our listeners understand the appeal process. For anybody who wants more information or who wants an assistance with an appeal, how can they get in touch with you?
I think the best way is just to go to my website. It's Ufferman.law.com. So U as an umbrella, FF as in Florida, ERMAN, Uffermanlaw.com.
Awesome. Well, thank you so much for talking with me today and going over the appeals process. It was really good to hang out with you and see you. So thanks for coming on.
Thank you, Jessica. It's been a pleasure.
Thank you so much for listening. If you found this episode helpful or informative, don't forget to follow us on social media and share this podcast with your friends. Like, follow, subscribe so you never miss a show, and help others know their rights by spreading the word. Your support helps us keep fighting back. The information provided in the Fighting Back podcast is for general informational purposes only and is not intended as legal advice. Every case is unique and should be reviewed by a qualified attorney who can provide guidance based on the specific facts and circumstances of your case. Listening to this podcast does not create an attorney-client relationship with Fighter Law or any of its attorneys. If you are facing any legal issue, we strongly encourage you to consult with a licensed attorney directly.